Hi guys, this is CA Balakrishna from lecturepedia.in. In this class, we are going to revise deposits chapter for CMA final level. Okay, from new syllabus. And if you want to purchase regular classes, you can visit our website lecturepedia.in and you can purchase the regular classes for CMA final law new syllabus, that is June 2023 attempt onwards. Hope this is clear. Now without any delay, let us start revision of deposits chapter. If you see, this chapter is a very small chapter. We just have 5 sections under this chapter. Of these 5 sections, only 2 sections are important and remaining 3 sections are small sections. So this chapter gets completed if we thoroughly revise 2 sections which are somewhat lengthy and 3 sections which are smaller sections. Now first of all, deposits. What are these deposits? Generally, deposits are a type of borrowing for the company. You can say that these deposits are short-term borrowings. In the same way, banks raise deposits from the public. Even the companies can also raise deposits from public and also from members of the company. Now, relating to this, the procedural aspects, and there are certain limitations which the companies have to follow while raising these deposits, which will be dealt by this deposits chapter. Basically, here we will be having section number 73 to 76A. First of all, we'll start with section number 73 and section number 76. Section number 73 is related to raising deposits from members. Okay, it is raising deposits from members, whereas section number 76 is related to raising deposits from public. Hope this is clear. Now if you see this chart, acceptance of deposits, basically deposits can be accepted by a company from members or from public. Now in order to determine which companies can accept deposits from public and which companies can accept deposits from members, there are 2 types of companies. One is eligible company and another one is non-eligible company. Why we have divided the companies into eligible and non-eligible companies? Basically, only eligible companies can raise deposits from public. Non-eligible companies cannot raise deposits from public. Hope this is clear. Whereas deposits from members can be raised both by eligible companies as well as non-eligible companies. Basically, eligible companies means companies which are eligible to raise deposits from public. Now what are these eligible companies? First of all, let us see eligible companies. Here is the definition. Eligible company means a public company. First of all, that company must be a public company with net worth of 100 crore or more, or turnover of minimum 500 crores, and consent of shareholders either through special resolution or through ordinary resolution. If these 3 conditions are satisfied, then that particular company will be known as eligible company. What are the conditions? First of all, the company must be a public company and either its net worth must be 100 crores, or you can observe it is or here, not and. Okay, or its turnover is minimum 500 crores and it must obtain either special resolution or ordinary resolution from the shareholders. Now when should a company obtain special resolution, when should a company obtain ordinary resolution, that one we will discuss later on. Now this is the definition of a eligible company. Eligible for what? Eligible for raising deposits from public. Here you should remember that private limited company cannot raise deposits from public. Why? Because private limited company can never be a eligible company. The first condition for eligible company is it must be public company. Hope this is clear. Now once we understood this eligible and non-eligible companies, let us come to this chart. Now raising deposits from members will be dealt by section number 73 and raising deposits from public will be dealt by section number 76. Now who can raise deposits from members? Both eligible as well as non-eligible members can raise, non-eligible companies can raise deposits from members, whereas to raise deposits from public only eligible company can raise deposits from public. Now in order to raise deposits from members, certain procedure has to be followed. This procedure is prescribed under section number 73. Basically here we will be having 5 points. What are those 5 points? Requirements. First of all, before raising deposits from members, the company must circulate advertisement in form DPT1. That is the first requirement. What is the first requirement? Company must circulate advertisement in the form DPT1. What will be present in this advertisement? In this advertisement it will say how much amount of deposits the company is going to raise and what is the purpose for which the amount will be utilized. All these aspects will be dealt in this advertisement. That is the first requirement. Second requirement is at least 30 days before issuing or circulating this advertisement, the company must register this form DPT1 advertisement with the registrar of companies. That is the second requirement. Okay, file DPT1 with ROC with at least 30 days before circulation. Third requirement, company must maintain deposit repayment reserve account. If company wants to raise deposits from members, it must maintain deposit repayment reserve account. Now to this deposit repayment reserve account, company must deposit every year at least 20% of the deposits that are going to be matured in the coming financial year. Okay, let's say presently the year is 21-22, let's say. Now in 22-23 deposits of amount 1 crore rupees are going to be matured. Then in the current year company has to deposit 20% of that 1 crore, that means 20 lakh rupees to this deposit repayment reserve account. That is the requirement, which is third requirement. Moving to fourth requirement. Now if company wants to raise deposits means there should not be any subsisting default. Default means, let's say in the past company has raised some deposits and company failed to repay that deposits, or company failed to pay interest on those deposits. That is known as default. Now if company wants to raise deposits as of now means it should not have any subsisting defaults. And also in case in the past company was having any defaults means at least 5 years should have been elapsed from the last date on which those deposits are made good. Let me tell you this with an example. Let's say in the year 2012-13 company has to repay some amount of deposit. Let's say company has to repay certain 1 crore deposit. Okay, company has raised deposits in the past and the due date for repayment of those deposits has fallen in year 2012-13, but the company has failed to repay these deposits in 12-13, but in the next year, that is in 2013-14, company has repaid that amount. Okay, in the actual due date company failed to repay, but in the next year company has made that default good. Now from the date on which the company has made the last default good, from that date for a period of 5 years, okay, in this 5-year period company cannot raise new deposits. Hope this is clear. Next, that is the fourth requirement. What happened to this? Coming to fifth requirement. If the deposits are secured deposits, then the company has to create a proper charge regarding the deposits. Generally regarding to this secured or unsecured deposits, one point that you have to remember is a company can raise only secured deposits from the public, whereas company can raise both secured as well as unsecured deposits from members. Hope this is clear. These are the 5 requirements relating to acceptance of deposits from members, which will be dealt by section number 73. Now moving to section number 76. Section number 76 deals with acceptance of deposits from public, and the deposits which you accept from public must be secured deposits, and only eligible companies can raise deposits from public. Now in section number 73 we have discussed 5 points now, 5 requirements. Of those 5 requirements, first 4 requirements must be complied even by these eligible companies which are raising deposits from public. Okay, same as A to D. What happened to this? Okay, same as A to D. That means first these 4 requirements which are applicable to raising deposits from members are applicable even for raising deposits from public also. What about 5th condition? If you come to 5th condition, actually you can raise either secured or unsecured deposits from members. So the 5th condition, the 5th requirement says that if secured, proper charge has to be created. But in case of public raising deposits from the public, the deposits will be always secured only. So 5th point is not applicable. If secured is not applicable, always they are secured only. So must be secured deposits only. There must be proper charge always created, and along with it company should also obtain credit rating for those deposits which you are raising from the public, and you should obtain general meeting ordinary or special resolution. In case you are raising deposits from members, you need general meeting ordinary resolution. If you are raising deposits from public, who can raise deposits from public? Only eligible companies can raise deposits from public. In that case you require general meeting ordinary resolution or special resolution. Now the doubt comes, when should company get ordinary resolution, when should company get special resolution? Basically this point, okay, which here I have told you that I will be explaining it later on. Now the time has come. Now this is actually linked to section number 180 subsection 1 clause C. Generally in this section, if company wants to raise borrowings, there are certain conditions prescribed. Okay, what is that condition? Let me tell you. First of all, existing borrowings plus proposed borrowings. Even deposits are also a type of borrowings. Now if existing borrowings plus proposed borrowings are less than or equal to paid up share capital plus free reserves plus securities premium, in this case for raising proposed borrowings, okay, for raising these proposed borrowings, company requires general meeting ordinary resolution, whereas second condition, if existing borrowings plus proposed borrowings, okay, if existing borrowings plus proposed borrowings are greater than paid up share capital plus free reserves plus securities premium, in this situation for raising this proposed borrowings, company require general meeting special resolution. Okay, these are the criteria that has to be checked in order to decide whether the company has to pass general meeting ordinary resolution or general meeting special resolution for the purpose of raising deposits from public. Hope this is clear. By this we have completed the discussion related to raising deposits from public from members. Next, now tell me whether the company can raise unlimited amount of deposits The answer is no. There are certain restrictions on the maximum amount of deposits that the company can raise. Okay, these restrictions are prescribed here. Let us see. Maximum amount of deposits that the company can raise. Basically, we have divided the companies into two types. One is eligible company, one is non-eligible companies. So there is different limits for eligible companies and different limits for non-eligible companies. So first of all, we will see for eligible companies what are the limitations. Now, if the eligible company is a government company, in that case, maximum amount of deposits that the eligible government company can raise is 35% of paid up share capital plus free reserves plus securities premium. In case eligible company is other than non-government company, okay, other than non-government company, in that case, you have to further bifurcate it into the amount of deposits that can be raised from members, the amount of deposits that can be raised from public. Okay, in case of government companies, together both from members and from public, maximum limit together is 35%, whereas for non-government eligible companies, the maximum deposits from members is maximum 10% of paid up share capital, free reserves plus securities premium, and maximum deposits from public is 25% of paid up share capital, free reserves plus securities premium. That is the maximum limit in case of eligible companies. Now going to non-eligible companies. Now even in non-eligible companies also there will be public companies. If their turnover is below 500 crores, if their net worth is below 100 crores, then they will be non-eligible companies. Now for a public company which is a non-eligible company, the maximum amount of deposit that it can raise both from members and from public together is 35% of paid up share capital, free reserves plus securities premium. Okay, and for a private company, it can raise 100% of paid up share capital, free reserves plus securities premium. And if the company is a startup company or a standalone private limited company, then there is no limit of maximum amount of deposits. It can raise whatever the amount of deposit it wants. That is related to limit of deposits. Next, tenure of deposits. Tenure means maturity period. Okay, once the company accepts the deposit, it can't keep these deposits with itself only. It has to repay the deposits to that particular deposit holder. Now, what can be the maximum tenure and what can be the minimum tenure? Generally, the tenure of the deposits should not be less than 6 months and should not be more than 36 months. Hope this is clear. That is 6 months to 3 years, you can say. Now, there is an exception for this minimum period. Company can raise deposits with tenure less than 6 months, but not less than 3 months. Okay, minimum tenure must be 3 months. Okay, even in exception case also minimum tenure must be 3 months. Okay, now this can be raised up to 10% of paid up share capital, free reserves plus securities premium. See, deposits with tenure more than 3 months and less than 6 months can be raised maximum up to 10% of paid up share capital, free reserves plus securities premium. Next, by this entire 73-76 got completed. Now moving to section number 74. Generally, if you see, these provisions related to deposits has come into existence from 1st of April 2014. Okay, now before 1st of April 2014, companies would have raised deposits, right? Under previous act, companies would have raised deposits. Now the requirement as per section number 74 is that all the companies which have raised deposits before 1st April 2014 has to repay those deposits within 1 year from the date on which these provisions comes into existence. That is the requirement of section number 74. Here I have given you a example. You can go through with that. And if the company wants extension, okay, if the company feels that it cannot repay the previously accepted deposits within a period of 1 year from the date of 1st April 2014, then it can make an application to the tribunal asking for an extension of the time. Then the tribunal will grant the extension. Now that is section number 4. There is section number 75 which is related to section number 74. Now, if a company failed to repay the previously accepted deposits within the period and it was found that the directors or the company has raised the deposits with a fraudulent intention. Their intention itself is to defraud the deposit holders. In that case, the company and the directors of that company will be guilty of fraud, and they will be charged with a punishment related to fraud that is specified under section 447. Okay, that is section number 75, which is related to section number 74, damages for fraud. If it is found that the intention of the company itself is to defraud the deposit holders, then the company will be deemed to have committed the fraud and it will be liable to penalty under section 447. Next, section number 76A. Now, if company contravenes section number 73 and section number 76, then punishment as per section number 76A will be imposed. What is the punishment? See, on company, fine not less than 1 crore rupees or twice the amount of deposit, whichever is lower. That will be the punishment or the penalty on the company if it contravenes section number 73 or 76. And on the officer in the default, he will be liable to a imprisonment which may be extended to 7 years, and also fine not less than 25 lakhs and which may extend to 2 crore rupees. That is section number 76A, which is related to penalty. Here in this chapter, section number 73 and 76, these two questions are most important questions, and you can expect the questions in this two sections only. Hope this is clear. By this, revision of deposits has been completed, and if you want to purchase regular classes for CMA Final Law under new syllabus, you can visit our website lecturepedia.in and you can place your order. Okay, take care, bye bye.